Hi, everyone. My name is Tara Spalding. Thank you so much for joining us at Boom Startup. This is an OpenUp session on document fundamentals for funding. Today, I have Mark Rasich from Stoll Reeves joining us, and he's going to be sharing an update on what is needed when you are fundraising when it comes to documents. And let me tell you, fundraising is all about documents. Mark, thank you so much for joining us.
My pleasure.
Before we get started, I want to say thank you to Mark as well as his firm Stoll Reeves. Stoll Reeves provides comprehensive legal services to startups, and Mark is based in the Salt Lake City office. However, they assist clients all around the United States as well as some in Canada.
Some in Canada,
yeah. For more information, please go to stoll.com. If you're new to Boom Startup Accelerator, welcome. As you figured out so far, to participate in our programs, it is super easy. Everything is open and it is opt-in, so you show up to what's helpful for you. Our vision is to give an aha moment to every single startup that comes and listens to programs such as this. And we also provide expert resources such as Mark and tools, as well as hands-on programs and homework assignments to help you better your business. We serve companies that are located all around the globe, as well as several different industries, and that's primarily because our topics are about financial education and funding preparation. Boom Startup provides 4 different programs. We have PitchUp, which is our pitch competition. Mark has been a judge for the last 2 events, and it's a really fun global event, open to all and provides cash as well as services to the winners. And then programs such as this workshop fall under the OpenUp program, which are drop-in education. Plus we have Rise Up Sprints. They're intensive 1-week programs that pair you up with an expert to solve a specific business need. And you also get to meet other founders with similar problems. And last and certainly not least is Amplify Up. And this is the source of our conversation today. We help fund high growth potential startups with the right capital and investor supports through Amplify Up. And we also leverage our parent companies, Assures, SPVs, to also make the funding round open and accessible for outside investors to participate. Amplify Up provides the first meaningful capital boost to high growth potential startups. We have an 8-week program that focuses on funding preparedness, the diligence process, as well as direct investor support. So not only will you be funded when you graduate Amplify Up, but you'll also know how to approach and speak to your own investor base. And of course, when it comes to funding in the organization, most of it is outlined with documents. So that is a great way to segue into today's conversation, which is about document fundamentals for funding. This is a narrative, hour-long discussion, top-level details about documents, because if you don't have the right documents, it will kill the deal. My guest today is Mark Rasich. He's a partner at Stoll Reeves. Mark, can you tell us a little bit about your background and how you got into this?
Sure. I'm a litigator by training, which means I see just about every type of business dispute that there is, and have seen such disputes over the course of my career, helping clients on both the plaintiff and the defendant side. And based on that experience, I started, several years ago now, to work with clients to try to identify and mitigate risk of litigation, but also to help them identify and monetize their intellectual property, and then ultimately that led into helping clients get prepared for and find funding. So that's what I do. Stoll Reeves itself is a international, if you count Canada, national firm if you are talking about North America, a full-service business law firm helping clients from the smallest solo entrepreneur all the way up to Fortune 500 and everything in between, with largely business related issues. So in other words, we don't do a lot of criminal law unless it's white collar crime, or and no, to my knowledge at least, no personal injury and no marital family law issues. But otherwise, if it has to do with a business, we can help you.
And Mark, you and I have known each other and worked with each other for so long. You have covered so many topics from employment, IP, mergers and acquisitions, funding, etc. I mean, how many companies do you think you've worked with? Like hundreds, thousands?
For sure, hundreds. I don't know if I would go all the way to thousands.
You're still young.
Yeah. Got plenty of years to get there. Yeah.
No, but I think you definitely have seen and spoken to so many people, as well as witnessed so many situations where, I mean, how many times have the situation been preventable?
Yeah, I think at least you can mitigate risk. I won't. Anyone can sue anyone for anything in America, but you can generally mitigate your risk by preparing up front and getting help earlier on in the course of your business life than later.
Well, and let's drill into
penny wise, pound foolish is
foolish, right?
What usually happens. If you wait, it's almost always going to cost more than if you jump in at the beginning. Do it right the first time will cost you less money than fixing it later.
Yeah, absolutely.
Which applies to preparing your documents and doing your due diligence preparation just as much as anything else.
Yeah. Mark, can you tell us a little bit more about what you're going to cover today?
Sure. So what we're hoping to cover in the next hour or so is everything that a high growth company looking for funding will need to consider in preparing to go out and ask a company, an investor, whether that be a professional investor or friends and family that maybe wants some more information, needs to know and needs to think about in order to be in the best place possible to go and ask for that money. That starts from, as the slide here suggests, from fundraising processes, due diligence basics, and then we'll deep dive into more specific things related to due diligence, because ultimately due diligence is where the potential investor investigates, analyzes, discovers, and figures out whether all the things they're hearing from a founder are true and accurate, believable, and achievable. So that's what we're going to be talking about.
Well, and it's very important. Now, the fundraising process, according to Boom Startup, really has 5 distinct phases or steps. Out of the gate, viability preparation is probably the first and foremost important step, because it really figures out if your innovation can actually be supporting a business itself, and if the business has a viable market and is readily and rapidly growing or not. The next aspect is entity formation. We'll talk about that in a moment. But after you formalize your company, that's when, in fact, you can start putting together the investment plan and then move into the investor pitch and funding, plus the post-close activities. I meet so many entrepreneurs that are just like, I'm ready for the investor pitch and fund. They're on step 4, and they forget these 3 very important steps. Now, the second step, the entity formation, is really important. Can you shed some explanation summary as to entity formation?
Sure. So like Tara said, I mean, at the end of the day, Tara has seen and I have seen innumerable numbers of entrepreneurs arrive with the pitch deck. And usually, even the somewhat more experienced serial entrepreneurs sometimes jump from I have an idea to I now have a pitch deck, and they skip over the 3 or 4 steps in between, one of which is deciding how you're going to form your company and what type of company you're going to form. So the reason why that matters is because not any, but most significant angel and early stage investors that do this for a living rather than friends and family are going to want to see formation documents and corporate records that are consistent with the way that they have seen them done in the past, that are familiar to them, and which they understand because they've seen them so often in the past. So when you're forming your company, you can form it as an S Corp, you can form it as a C Corp, you can form it as a sole proprietorship, or you can form it as an LLC, all of which are legitimate forms of a company for forming a company or a business. But depending on what you ultimately want to do, you're going to need to choose a company or a type of company entity that is familiar to your projected investment source. Some investors are comfortable with LLCs, some are not. Almost all investors are comfortable with the Delaware C Corp because Delaware is where most companies are founded. Delaware law is very well settled, so they know what they're getting if they see a Delaware C Corp and documents prepared properly under Delaware law. So that's why entity formation is important. To our earlier point about penny wise, pound foolish, many founders choose to form an LLC or operate a sole proprietorship in the beginning, and then they decide they need to raise money. And almost always, it costs more money to switch from an LLC to a C Corp than it would have to just have started with the C Corp. Of course, there's some formalities and things like that that each individual circumstance will have to address. But in general, if you're choosing and you know you're going to raise money, there's almost never going to be someone who is afraid to invest in a Delaware C Corp. You may come across some that just are not comfortable doing it in an LLC, particularly one that's not from Delaware.
Right. Hey, Mark, we have about 30% of our contingency in the Boom Startup Accelerator community, not from the United States. And in fact, often we're asked, I have a foreign entity, yet I am considering creating a U.S. entity because it will not only help me attain U.S.-bound customers, but also U.S. investment. Can you talk a little bit about structuring or having some sort of relationship with the foreign entity as well as a U.S. entity?
Yeah, so we get this kind of discussion going quite a bit. And the first thing I'll say is every situation is unique. In each situation, you should be looking for and finding advisors who can help you from whether that be from an accounting perspective or a legal perspective or business perspective. But having said that, so if you're out there and this is your question, you need to talk specifically to an accountant, a business advisor, or a lawyer about your specific scenario. But broadly speaking, there's no prohibition, no blanket prohibition on a foreign entity forming and owning the Delaware C Corp, for example. And in the circumstance where you're a foreign entity who wants to do business in the US, who wants to raise money from US investors, that is often the way to go about it. Form an LLC or form a Delaware C Corp that your foreign entity owns. Doesn't mean that in due diligence process, a potential investor isn't going to move beyond the fact that you have a Delaware C Corp to see who you are, where you're from, what kind of business entity you are in your jurisdiction. But it will again be a form that most investors are comfortable with. They know what they're getting, and so that will not be a cause of particular amount of friction.
And if they do create a US-based entity, doesn't it give them advantages, for example, for filing patents, etc.? So there are further legal protections.
So there's no prohibition on a foreign individual filing for a patent in the US. But what having a Delaware C Corp does do is, in some instances, gives the general public, business people you might do business with, contract with, comfort that you're for real, even though the owner of that company may not be in America. So I don't think there's a particularly significant amount of additional protection, or maybe protection is not the right word, benefit to filing and owning a Delaware C Corp. But if you're going to raise money, it helps. And it probably, from a tax perspective, maybe it makes a difference. And of course, anyone who's thinking of doing it needs to talk to a tax advisor, not me in this general discussion of issues.
Well, and thank you for covering incorporation. There are other important aspects on there, which are like the HR.
Yeah, and we'll get into all these, but basically, while the heading of this little piece is entity formation, really we're talking about proper documentation of your business. That starts with what kind of business you have.
Okay.
Did you form it properly? Do you have the documentation to show that you formed it properly? Do you have documentation to show that all major actions of the company were done properly and documented properly? Do you have employment agreements? Do you have employee manuals? Do you have privacy policies? Do you have terms of use if you're an online, which almost everything is nowadays, an online business? Do you have a cap table? Who owns what? Who claims to own what? Who's out there that might come out of the woodwork when your business starts to do really well? All of these things are things that a potential investor wants to know. Other kinds of agreements, inbound contracts, outbound contracts. Is there somebody's IP that you're using to make your widget that's critical to your widget? Do you have a solid agreement with that company? What happens if you take on investors? Does that agreement have some sort of change of control or anti-assignment provision? And any fundraiser needs to understand what their agreements say, because any potential source is going to want to know what they say to make sure that when they invest, they're getting what they invested in and what the founder said they were going to get. Bank accounts and EIN are self-explanatory. Probably aren't doing business if you don't have a bank account and EIN.
Yeah, where do you get the check?
Yeah.
Where do you send the money
Where
to?
am I going to put the money? It's not going to come in cash,
Yeah.
generally speaking.
No, it's very true, but I think it's always the important fundamentals of don't skip it. Mark, what happens if people are at the investor pitch and fund component and they get the first, I'd like to dig in a little bit deeper, but the information isn't there? Why is this a problem?
So the folks out there may have heard this, but time is a deal killer and friction is a deal killer. Funding sources in general are looking for a reason to say no. Friction gives them a reason to say no. Too much time gives them a reason to say no. Friction leads to time. So a potential source is looking for things. It's looking to see, does the management know what they're doing? Is the business plan sound? Are the financial projections sound? Do they operate the business the way the potential funding source wants the business operated? If you start off the game without having proper documentation, it's going to call into question the bona fides of the management, and certainly is going to make a potential funding source take more time to dig deeper into everything that a founder says, every projection made, every financial estimation, everything that is said after that comes into question, which creates friction, takes time, and potentially kills the deal.
That's so true. The faster that you can provide the documentation that, in fact, it is an investable business, the less friction it is. And expediency, especially on response and review of the material, is absolutely critical. It's the fear of missing out that you want to capitalize on. It's the impulse action of the investor that you want to take advantage of. If too much time lapses, then that's certainly a deal killer. I'm saying it with my Utah accent. Deal killer.
Killer.
We have interesting ways of using our E's and I's here in Utah, if you haven't picked up. All right, so let's talk about due diligence basics. At an overview, you'll hear the term when you get the first yes after you do your initial introductory pitch, that they'd like to know further information and they'd like to proceed into due diligence. Can you explain a little bit at a high level?
Sure. I mean, we kind of just touched on it a moment ago, but basically due diligence is the process by which a potential funding source reviews everything there is to review about the potential investment to determine whether it's worth the risk. And of course, the more you want someone to invest, the more due diligence they're going to do, and the more, because they're risking more money. Of course, the less you want them to invest, the less due diligence they're probably going to do because they're risking less money. So what is it? It's basically digging into everything you as a founder might tell that potential investment source, all the documentation that you have as a business, what documents you have from when you formed to where you are now, what agreements you have, what financial records you have, what tax returns or you do or don't have, what audited financial statements you do or don't have. everything in between. Why is it important? We talked about that just a moment ago, but basically your goal is to make the due diligence process move as quickly as possible, to have support for everything that you say, document everything that you say you're going to do or have done, so that a potential source looks at it and says, okay, I heard all of these things in pitches. Now I see all of these things are true in the documents. I think I can invest in this company because what the founder says is true is true. So what's the outcome for you? You want the outcome to be, oh, look, I have an investor. The investor likes what I've said, and I'm a good match for this investor. And the investor wants the same. The investor wants to know that they can rely on what you say, that you are a good operational manager, that you know what you're doing, that you have reasonable projections, that you have reasonable pro formas, that you take care of the things that you can take care of, i.e. you document things well from the beginning, because there's lots, as everyone knows, that you can't control. So controlling what you can control gives investment sources comfort, and that's what we all want, because that leads to the deal.
I think another outcome to add on to those really important points is that when you're in the due diligence process and how you share this information with the investor establishes a pattern of communication. When they invest in you, it is very, very wise to continue those communication points, as well as update or give them the same updates on the information that they originally saw. This keeps them in the positive side of your relationships. They can become advocates and they can help you out in your future rounds of funding. So when you think of the due diligence basics, it's not just for this round, but it's for every single additional dollar you raise going forward.
And I mean, to that point, many investment sources will negotiate for information rights and put information rights into the deal documents, meaning they're going to require, among other things, that you provide periodic updates to all of the financial information, to all of the business projections, basically to everything that they find of most interest through their due diligence process. Information rights are a pretty common topic of discussion, even if they don't make it every time into deal documents.
Yeah, no, this is great. So the due diligence always starts off with granting access to what's called a deal room. And for those of you who are new to deal rooms, it is a digital drive that's accessible to people who have the right credentials to access it. The drive is really important to set up correctly when it comes to security process because, of course, it contains all of the most important information about your company, about your staff, and your plans, and your financials, etc. Like, you want to talk about like private data, this is the center of it. So with that sort of mindset, you want to make sure that you have very strong access control into the deal room, and that you can also monitor who's logging in, and also if they have read-only access or edit-only access. Some of these components or documents need to be updated on a periodic basis. For instance, anything financially related at the end of the month should possibly be refreshed. Other documents, like insurance policies, may not even change, like maybe once a year, right? So it's really important that you keep a list as to what documents are in there, when was the last time that they were refreshed, and when they should be refreshed again. The other list that's important to track on your deal room is who has access, what kind of access do they have, and when should their access be revoked. Like, for example, if you have prospective investors who go through the deal room, yet pass in the deal, then you should renege their access to the deal room and the content itself because they're not investing in you. But Mark, if you can go through the different deal room documents and like, do people need this all at once, like right out of the gate for their first pre-seed round?
Yeah, so let's take a giant step back here. So basically this slide lists all of the categories of documents that could be required in a deal room depending on the type of deal and the type of company and where the company is in its life cycle. Obviously, a company that is essentially a really good idea with a business plan but no operating history, there's going to be lots of documents on this list that just don't exist yet. On the other hand, if you're seeking your last round of financing before you go and try to go public, you're going to have not just these, but probably even more than what these categories of documents are, and you're going to have them going back for years. So where a company is on a spectrum between essentially an idea and I'm waiting for my last round of money before I go public is going to determine in many respects how much of these documents you have, and also how much of these types of documents a potential investor wants to see in a deal room. The categories are, relatively speaking, self-explanatory. You're going to want to include all of the documents that you have from formation through the day you do your deal, in terms of incorporation documents, in terms of corporate documents reflecting corporate actions. So that could be issuing shares or issuing membership interests if it's an LLC, all major actions of the company that have to be approved by a manager or managers or members if it's an LLC, or a board of directors, or shareholders if it's a corporation. You're going to need to have all of your material contracts. These can be anything from topically material, so even if it's not a big dollar at stake, but it's a particularly important part of your product or service, that's a material contract. If it's an expensive contract, if a lot of dollars are at stake in that contract, that could be a material contract. Assets and taxes are kind of self-explanatory. What do you have? What do you own? What have you paid or not paid before? Cap table, self-explanatory. Who owns it? Who claims to own it, meaning your business or a potential piece of your business. Term sheets and purchasing agreements. I'll let Tara take that in a minute. Loans, liabilities, litigation, self-explanatory. Who have you loaned money to, on what terms? Who's claiming that you owe them something, for what, in litigation or liabilities? Financial statements, again, self-explanatory. Employment contracts and agreements. Here, a potential investor is going to be most interested in, hey, do you have employment agreements, or do you have only third-party consulting agreements? And if you have employment agreements, what are the terms of those agreements? Do they have things like non-competes or non-solicitation agreements? Do they have non-disclosure provisions, or is that a separate agreement? Do they have invention assignment agreements whereby your employee has prospectively assigned to the company all of the intellectual property that employee creates on the job or with company resources? Similarly, when you get to intellectual property documentation, an investor is going to want to know you own what you say you own what is important to your company, or you have rights to someone else's intellectual property if that intellectual property is important to your company. So that's in part licenses, it's in part non-disclosure agreements, it's in part invention assignment agreements, or just pure assignment agreements if it's third-party consulting work. Insurance policies, again, that depends on the type of business, but you might have directors and officers liability insurance. If you're a real estate company or you're running a gas production company, there's going to be all kinds of insurance they're going to want to see that you have.
Data security.
Way past what I am familiar with, but data security, if you're collecting information, they're going to want to know that you have cybersecurity policies to the extent you can get them. There's all kinds of insurance. Again, the earlier you are in the life cycle of the business, the less concern that's going to be. The later you are in your life cycle, much, much more important. Technology and innovation documents kind of overlap with intellectual property, but basically, what is your technology? What is your product? What makes it cool? What makes it different from what's out there? If you have patent protection or trade secret protection or copyright protection, is it broad enough? Is it both particular enough and broad enough to prevent a better funded competitor from jumping into the market space and taking over market share? Market docs, self-explanatory. What research have you done on the market? What does the market look like? How big is it? What's the total addressable market that you're claiming? What are the support for all of those pieces of information? Financial projections and sales, same thing. And KPI, very important that you have KPI information. Again, depending on where you are in the cycle. If you're brand new, you have an idea, there isn't going to be any KPI because you haven't done anything yet. Doesn't mean you can't get investment. It's going to be a little bit harder. You're going to have generally almost no documents, but hopefully you have some proper formation documents. But KPIs as you move on are going to be important. Why? The investor wants to see that A, you know what a KPI is or what KPIs are important for your business in your market, and B, that you can meet those, your own self-imposed, I'll call them, projected KPI numbers. So that's a whole lot of talking about what's in the deal room. Each deal room is going to be different. It's going to depend on the type of business, where that business is in the life cycle, and also on who the potential investment source is, because each of them will have their own ideas of how much they want, how much they expect you to already have or not have.
Well, and I think this is a great recap of what to expect after you win the very first meeting. Boom Startup Accelerator, for our Amplify Up program, we asked for basically a few of these, not all of them, to be accessible in our deal room. For example, the financial statements, the financial projections and sales, and the KPIs, as well as the credible investment ask. But before the due diligence process begins, you need to win over the hearts of the investor. And the other aspect that Boom Startup Accelerator focuses on is the initial presentation that we do during our demo day in Amplify Up. We do have a different subset of documents than what's in the due diligence process, but it's important that you as a founder understand that to present a fully baked investment strategy, you certainly need these solutions. The one-pager summary is exactly that. It's a front side page summary as to your business. It's a great way for Boom Startup Accelerator to introduce you to the investor base without them even knowing or meeting you. The teaser demo video, we asked for a 90-second video so people can start getting a feel for your innovation. And it's really important because that's when your character and your excitement comes out. The teaser deck is different than the introduction deck, and I'm going to articulate this real quickly. Teaser deck is about 7 or 8 slides, and it has the narrative written on it on the 7 different aspects of your business. We have a template, and we suggest that you follow it, but it's something that if we hand out the one-pager summary and someone wants a little bit more information because they're on the fence, the teaser deck and the teaser demo video are the follow-up items. Now, the teaser deck is different than the introduction deck, even though the messaging doesn't change. The reason being is because the introduction deck is what you use when you're presenting. You want less words on your slides because you don't want your audience to be reading instead of listening to you. You are the one that they're going to invest in, especially at this pre-seed round. It's not the words on the screen. So take your teaser deck, delete about 90%, and those are your introduction deck plus another 6 slides in addition. The demo script is also important because you never know when an investor is going to pull you aside and say, give me a quick demo. And the demo script should probably be about 10 minutes, which should highlight the features and functionalities as well as the benefits that are articulated in your introduction deck. Backup slides are also important. We definitely have an introduction deck template and flow, but it doesn't mean you need to stop there because you can anticipate questions about your business and investment plan, and you can put that into your backup slides. A great, for example, is a product roadmap or a hiring plan or a sales strategy as backup slides. Investor lists and investor questions is another thing that we ask for in Amplify Up so that you are proactive on reaching out and culminating your own investor base and your own investor relationships, because it's those sorts of long-term deep integrations with investors is how you move them over. Of course, we ask for historical financials, which is also shared in the deal room, the pro forma, which are the 3-year sales plan, which is also available in the deal room, the cap table, have a high level summary as to like who are the significant owners and if there's any allocations available for employee stock options, etc. That's important as a summary, but the detailed cap table and any sort of purchasing agreements are located in the deal room. Customer endorsements, huge thing that we ask for you to provide up front, because that in fact is a proof of traction, especially for early stage. And then the term sheet, what is your proposed investment amount that you're asking, and what sort of valuation or valuation cap, as well as the investment instruments such as a safe or a convertible note. And then of course the KPI reports have a high level summary, almost like a dashboard, and then the rest of the reports can be available.
And I'll just add to this that while these are specific to the Amplify Up program, which I encourage you all to participate in, even if you were going to do something not directly through the Amplify Up program, all of these things should be created anyway. It's not that Amplify Up is trying to have you do something that you wouldn't have to do anyway. What they're doing is helping you prepare the things that are going to be required and prepare them in a way that will help you to attract investors, including Assure itself.
Yeah, thank you, Mark. It's so true. This isn't unique. And when these are not created, Mark, you have a really good analogy.
So I think we're talking about the same thing, but the bottom line is if you think about fundraising as you trying to get to the airport to catch a flight. If you get to the flight takes off, you've made your money, your business takes off. If you don't get to the flight takes off, someone else takes the money that was scheduled for you and they take off. So if you think about that's what you're trying to do, you take your house to the airport, you're all obviously going to see quite a few, well, at least for me, you're going to see quite a few stoplights. And if you think about funding as a friction or a time problem, each stoplight represents a point along the path that you can either fly through, have to slow down for, or come to a complete stop. If you've done your documentation correctly, it's a green light. If you kind of have it, but it's kind of messy, or you have some things and you don't have other things, or they're in a format that's not correct, or it's not easy to find, you're going to hit a yellow light. You're going to have to slow down. That may mean that you miss your flight. If you have nothing, it's a red light. I almost guarantee you're going to miss the flight. If you miss the flight, you miss your money. So do what you can to put the documents in place in the format that your potential investment sort is comfortable with, in the time that they want, in the way that they want, as fast as you can and as often as you can, and you'll hit the most green lights, which means you got the best chance to catch the flight.
No, I think this is the best analogy possible. And you know who's driving the car that's racing to the airport is the CEO. Oftentimes I'm asked the question, well, is it the responsibility of the CFO to make sure that the pro forma or the historical financial information or tax information is in the deal room? And the answer is yes, you can delegate, but it's still your responsibility as a CEO that everything cuts mustard. And it's you that are driving it through the car, and it's up to you to make sure that all of the lights are green. Unlike driving around here in Utah, I do not have the green light button. I know. And traffic is.
But the founder has the green light button.
But the founder has the green light button. The CEO has the green light button, and they should absolutely be queuing up and doing as much work as possible, so that there is no friction between they and the investors who are interested. All right, can you talk a little bit about how due diligence matures as businesses mature?
Sure. So we touched on this a few minutes ago, but if you think about, like this slide suggests, there's the life cycle of a business. It's a sliding scale from just getting started to fully mature and looking to either get a massive amount of private equity if it wants to stay public, or go or stay private or go public. Along that sliding scale, typically the amount of money you're asking for differs, and the risk differs, and therefore the needed or requested or required return will often differ. So will what's required at the due diligence process. If you're at the early stage, pre-seed stage, as the slide suggests, you're really just talking to friends and family, maybe a few people that you know. If you're really early on, those folks are probably gonna, if they're friends and family, they're just giving you the money and they're probably not all that worried about what the return is gonna be. They know the risk is high. Once you are outside of friends and family, you're at incubators, accelerators, SPVs, those sorts of things. They understand the risk. They're only going to give you, they're only looking to give you a, relatively speaking, little amount of money, but they're going to want a bigger return because, of course, they're taking a higher risk. They're investing before you're a proven business, before you've met years and years of KPIs, hit your marketing numbers, hit your sales numbers, hit your profit numbers. When you move on from seed to pre-seed to seed, you've been around, you have more documents, you have more information to provide. So the due diligence process is going to be a little bit more intensive because you're going to probably be asking for more money, and you will have more information for the potential source to look at. After seed comes series. There's A, B, C, D. There could be even more than that depending on the type of business you're in, or the type of market you're in, the type of business you're running, how you want to do it. But ultimately, again, more information because you've been around longer. They're going to seek more information because they're investing more money. And in general, they're going to understand that if your business now is successful, you've raised money many, many times, they're not going to demand necessarily, or expect, maybe expect is a better way to phrase it, quite the same amount of return on a multiple basis as, say, a seed money person might. And of course, late stage is late stage. You've been around for a long time. You're looking for real money to take it from a high growth, doing very well, to blowing up because you're going to either keep it private but blow it up, or you're going to go public, and the only way to do that is to really explode the market.
Well, and let's talk about this because, you know, when companies go IPO, they have to file with the SEC all of their activities, and frankly, they're audited. You know, they're financially accountable and could actually be, you know, sued if things are incorrectly filed and reported, etc. It's a big deal. Now, at the pre-seed round, especially with where Boom Startup starts, our investors really don't look for audits. However, there certainly is a level of professionalism that I think companies that are more inclined for rapid growth to do things right in the beginning and to hire the appropriate professional staff instead of it all falling on the burden of the CEO to create and produce these reports. Right. Mark, can you talk a little bit about how having experts and professionals come in, not to like the audit level, but make sure that the information is, or the documents are properly being created and handled so that it's a smoother success to growth?
Yeah, I would say that the easiest way to think about it is most investors want the business people running the business. So if you're a founder, you're the CEO, they want you to spend your time running your business, developing the new product, selling the product or service, taking care of customers, taking care of suppliers, those sorts of things. And they anticipate that a well-run business will hire outside folks, or bring them in for that matter, to handle proper documentation, proper accounting, those sorts of things. Because essentially they want the expert to do the work that an expert does, because they're going to be more efficient at it. They're going to be better at it because that's what they do. The business people should run the business. The accountants should do the accounting. Lawyers should do the legal work. And by doing that, if you're a founder, I have found from my own experience in terms of dealing with them that they have more time to think about the things that make their business what it is, to grow it, to improve upon it, and they have a somewhat lightened burden in terms of mental anguish because they have delegated where they could delegate to the right person. So whether that's an internal CFO, a fractional CFO, an internal general counsel, an external, part-time general counsel kind of thing. In either scenario, the CEO takes his or her strengths, uses those strengths to build the business, delegates to others who have different strengths to do those parts of the business. And from the investor perspective, again, it makes for good optics. An investor sees that the CEO or founder is focusing on what they're good at, but are smart enough to hire people to do the other things that they're not so good at, so that the business as a whole is lifted.
Yeah, well, and let's just talk about this. Investors certainly respond viscerally better when they know that the incorporation and the agreements have been handled by Stoll Reeves versus, oh, I did it myself. There is an absolute sort of improvement in reception because they know it's in fact defensible, etc. And investors are really happy to make those sorts of investments to bring in the right sort of professionals to do it better and smarter, because in the end, it's actually cheaper.
Yeah, I think there's lots of, I don't want to say that only Stoll Reeves can do it. There's lots of law firms, and many of them can do a very good job. So, but yes, I think that an investor or a potential investor does find comfort in knowing that a company has used reputable counsel along the way, not just for forming the company, but for reviewing contracts, for drafting contracts, for dealing with employment issues, privacy policies, terms of use, those sorts of things. Of course, there's lots of forms that exist in the world. Some of them may be just fine. Many of them are much less than fine. And in general, a person that started their own business probably isn't able to tell and doesn't have enough time to tell when something they found on the internet is in fact good enough or not good enough. And so a potential investment source who knows that a founder or CEO has consistently called upon outside experts if that's what the financial situation allows, or internal experts if that's what the financial situation allows, to perform those services, it gives them that comfort that you described. And of course, Stoll Reeves can do it, but other firms, just to be fair, can also.
Yes, absolutely. No, I appreciate it. So let's talk about the 4 different buckets that these documents are grouped into the due diligence room, and why these buckets are important. And the first one that we have up here is business bucket.
Right. So you all will remember a few slides ago we listed 20 different categories of things, and this is going to give you a little bit better way to organize those documents in your deal room, because when you're a potential investor, you're looking for 4 categories of information, and you're going to expect a different volume of information in each of those 4 categories in the deal room. But in essence, and they may not call it exactly the same things as we're going to label them here, but they're going to be basically the same buckets. So the business bucket is just what it sounds like. What information do you already have prepared that you can put in the deal room related to your business? Do you have a business plan? What is that business plan? Does the business plan contain reasonable projections, reasonable goals? Do you have a cap table? What's the cap table look like? Who claims to own some piece of this business? Whether it's in the cap table or otherwise, you're 100% going to be asked to provide any other information that you have or that you know about anyone else who claims to own some percentage, or may claim to own, or may in some contingent world own some piece of the business. Because again, the investor is looking to say, all right, I've been asked to invest X amount of money for Y% of the business. I need to know that if I invest X amount of money, that I will in fact have Y% of the business. And anything that that calls that into question, creates fiction, creates problems for completing your deal. The cap table is one place that the investor is going to look at and say, okay, I can see here, so long as there's no other skeleton in the closet, that I'm going to get what the founder says I'm going to get for my investment. Market analysis and competition, straightforward. What have you done to figure out what market you're in, what the competition is like, what sets you apart from the competition, what gives you that advantage over the competition? Is that advantage significant enough that it can last into the future?
No, I think that's great. How about finance?
So finance is just what it sounds like. What financial statements do you have? If you're an early stage, you may have 0 actual statements. You may have plenty of projections, but 0 actual statements. Likewise, may or may not have tax filings. Budgets, of course, are important. Use of fund statements are important. Any investor is going to want to know what you're going to do with the money. And just to answer an obvious question, most investors understand that at least at some point along the path, it may not be immediately at the pre-seed stage, but at some point along the path, founders and other investors are going to take some of the funds for themselves. Maybe that's because you're as an investor are buying the shares or some percentage of shares that these other owners have. So don't be afraid of being upfront about that if that's where you are in your life cycle and growth and what you're actually going to do with the funds. It does you no good to pretend like that's not going to happen, because they're going to figure it out and they're not going to be happy. Earlier stages, of course, they're not going to want to see that you're going to take the money and put it in your pocket. They're going to want to see that you're doing something significant for your business to keep it growing, to help you reach the goals that you presumably have in your financial projections.
Yep. Third bucket is technical.
So if I'm a potential investor, I'm investing in you and I'm investing in your product or your service. So I want to know what your product or service is. I want to know what intellectual property rights are tied to your product or service. I want to know what makes it different. I want to know what makes it better. I want to know what gives you a competitive advantage in the marketplace. And I want to know, hopefully, that you have protected that intellectual property, that product, that service in such a way that you can maintain that competitive advantage even against better funded companies that are out in the same market. Similarly, the last bullet there, process, supply chain, same thing. Your widget is made up of a lot of other widgets or material, pieces of natural resources that go into making your widget. How are you getting all those? Where are you getting them from? What are the limitations on those material parts of your product or your service? How have you protected them? How have you protected them legally? How have you protected them physically? That sort of thing.
Yeah, and technical doesn't necessarily mean that this is for high-tech companies.
Not only, yeah.
Yeah,
sure.
My goodness. Technical can also be, for a restaurant business. And this can be everything from how they run their line, their recipes, their buyers, their brokers, etc.
Yeah, product information. You can be an ice cream company.
But it has to be technical. It has to be a deep dive. It can't be ambiguous, because investors really want to get in and see how you run their business. And this is also a great opportunity for them to share their expertise or their network to help support and further your technical design. And the last is legal, and this is the fun one for you, huh?
It's the bucket that everyone loves to hate, but it's actually, in all honesty, one of the easiest buckets to fill and fill properly and to make sure that you have a green light. So if you assume that each one of these buckets is a place along the path to get into your cash plane, legal is the first one. It's probably maybe not the first, but it's one of the first, and it's, in all honesty, the easiest to take care of, because you either have it and it's proper, or you don't have it or it's not proper. And if you have it and it's proper, you got a green light. If you don't have it, it's a red light. Even the kindest, gentlest investor, the potential investor, is not going to invest in your business if you don't have proper documentation of the formation of your company, of contractual obligations of your employees, of your IP, ownership of your IP, of who or what or how people claim to own some percentage of your business. If none of that is there, or if it's not clear, you're gonna miss your plane. And that's the downside. The upside is it's pretty simple, may not be the right word. It is entirely within your control to do the legal parts correctly. Some of these other things, business, financial, and technical, it's subject to more vagaries. The potential investor may or may not like your technical information, may or may not like your projections, may or may not like your business plan. And that's just the subject of a potential investor's whims. You could probably find one who does like each of those three things. But none of them will go forward if you don't have the legal ducks in a row. And all of them will anticipate that you do. And you want to focus your time on the things that are much more within your control, much more what I would call soft skills, in the sense of convincing a potential investor that you have the right business plan, that your financials are proper and not pie in the sky BS, and that you've done what you needed to do to give yourself a technical advantage in the market. That's where you want to spend your time. You want it to just be a box checking exercise to say, yep, they have the right corporate documents. Yep, they have the right employment, IP, and contractual documents, because again, you're focusing your time on what you are expert at and what you believe in the most, and you've just taking one potential stoplight off of the road to the cash plan.
Well, let's dive into the legal due diligence. Even though you say it's black and white, there are a lot of intricacies within this. And the first segment is corporate formation and operations.
So, I mean, we've talked about it a little bit, but the first thing that you're going to do once you're passed on running a sole proprietorship is figure out what kind of business entity you want. How are you going to form it? What type of business entity? And each type of business entity has some pluses and some minuses, as you might suspect. Otherwise, everybody would just have the one form.
Well, there's tax and financial.
There's tax, there's financial, there's corporate documentation flexibility. Each type of company has different tax benefits and drawbacks, different corporate formality benefits and drawbacks. But generally speaking, most companies are going to be a C Corp, an S Corp, or an LLC. Those are the three biggest categories. You could have a limited partnership or a general partnership, but very few people do those sorts of things. So among those three, again, we talked about this earlier, you probably can find investors who are comfortable investing in an LLC. You can probably find investors who are comfortable investing in an S Corp. For sure, you're going to find investors who are comfortable investing in a Delaware, in particular a Delaware C Corp. And you'll notice that I keep referring to Delaware because, of course, you can file a C Corp in just about any state, but Delaware is the state where most investors are comfortable because that's where most companies are formed. That's where the business law, the law related to the operation and management and liability of companies, is most well defined. So they are going to be most comfortable if your company is a Delaware C Corp and you have followed all of the rules, which are essentially administrative rules for forming your company and then operating your company from there, which means bylaws, it means consents from the shareholders when necessary, consents of the managers when not necessary, or board of directors when necessary. And that's not for every single thing that your company does. That's for the big business things, the major contracts, the issuance of shares, or the purchasing of some significant piece of property, for example. What they're looking for beyond the basics is traceable ownership and compliance with security laws. If you're out selling shares in your company, you're going to have to comply with the securities laws. Securities laws are complex. There are many exceptions to rules. There's many rules, and there's almost as many, if not more, exceptions to those rules. If you are out selling or trying to sell securities or ownership in your business, you need to find competent counsel and talk to them from the beginning, and B, you need to document what you did all along the path properly, because the next round that potential investor is going to want to see that you did just exactly what I said. You dotted your I's and you crossed your T's, so there's nothing that could crop up later to create problems. Cap table is self-explanatory. Security interests in documents and other financial documents. Here, what we're talking about are things that could create ownership issues or liability issues for the company. It could be loans, it could be convertible notes, whereby someone has agreed to give you some money, and if you don't pay them back, it turns itself into some interest in your company. And again, essentially the owner, the potential investor, excuse me, is trying to figure out, did you start the company properly? Did you manage it properly? And if I invest, am I going to get for my investment what the CEO or founder said I was going to get for my investment?
That's awesome. Now, the HR and employment documents is very, very important because of not only the secrecy and the practices that are happening, but it also allows companies to protect what is being created or what's being innovated and own it. So can you dive a little bit into this?
So just as with the last slide and bucket and this bucket, I mean, what I would say to everyone who's watching and who watches this later is that each of these buckets are important, even if you're not trying to raise money. The corporate formation documents, they're important because you formed a company in large measure for some tax or liability reasons, let's say. If you don't take care of following the corporate formalities, you may lose those tax or liability protections. So even though it's important for a due diligence process, the reason it's important for a due diligence process is because those investors want to make sure that you have the benefits of the taxes and the protections of the liability protections of the particular type of company that you formed. Similarly, in HR or employment related documentation, you're starting a business. Your business is going to depend on innovation, products, services, sales, etc. Of course, employees are going to be important to that business. Third parties are going to be important to that business. Protecting the business means doing what you can to document the rights and obligations of the company, as well as its employees and its contractors. What does that generally mean? That means you need to, and a due diligence potential investor will look to see, do you have employment contracts, first of all? Yes or no? Do you have them for all of your employees, past and current? Do those employment agreements have the kinds of things that they expect to see, which are non-disclosure provisions, non-compete, non-solicit agreements in some places? In any business that or any employee has anything to do with product development or service development, they're going to want to see an invention assignment agreement. You're going to want to know if you have stock option plans and related things. You're going to want to see what you promise your employees by way of benefits. You're going to want to know if you have employee handbooks, privacy policies, bring your own device to work policies, data security policies, all of those sorts of things to get a feel for, again, how well you're running your business. And of course, a business that's just starting doesn't need every single thing that I just mentioned or every single thing you see on this list, but you should be thinking about it from day one. Okay, I'm going to hire employees. What types of employees do I want? For each sort of category of employee, what type of agreement would be appropriate for that employee? If the employee is a salesperson that literally never sees anything technical or proprietary related to the product, maybe they don't need an event or never participates in that. Maybe they don't need an invention assignment agreement, but certainly depending on your business and depending on your location, you may want them to have a non-compete because they may be a significant part of your goodwill with the client and you don't want them to leave, take all the ideas and training that you provided to them and start a competing business. So just as I said at the beginning, while all of these things are something that a potential investment source is going to be looking at, and they're going to be looking to make sure you put your business together properly and are operating it properly, even if you're not trying to raise money, you still should be considering each of these types of documents and putting them together in a way that makes sense for your particular business.
Yeah, absolutely. Now, contracts and agreements, I mean, this is just such a big bucket.
So this is a big bucket, but it boils down to the same principle. If you're an investor, you're looking to see, is the business well run? What does that mean? That means all the things we've been talking about. When it comes down to contracts and agreements, what it generally means is some version of, okay, you have a product. Do you own the product? Do you own all the parts that go into the product? Do you have agreements with suppliers for the critical elements that are used to make the product? Do you own a service? Do you own the software behind the service? If you don't own the software behind the service, do you have a license? What does the license say you can or can't do with the software that is part of the platform through which you provide your service? Do any of those agreements have provisions that change the nature of the agreement if a potential investor makes an investment? For example, is there a change of control provision? Is there an anti-assignment provision? All of those sorts of things are something that a potential investor is going to look at. In general, they're going to want to see that those contracts are well thought out, that the company has as stronger rights in its material contracts as it can have. And obviously, they're going to understand if you're a seed company and you've done a deal with AWS, that you're not going to be able to tell AWS what your contract says. But if you're a relatively speaking more substantial company and you're doing a deal with a third-party contractor who's going to write software source code, they're going to want to see an entirely different level of contract and a different level of rights that you have as the founder and owner of this company, right, that the company has vis-a-vis that third party than, say, AWS for hosting your service.
And the one thing I'd love to add onto the contracts and agreements that are very, very critical on identifying which areas that the investors are going to pay attention to actually starts with your business model. So business models, basically, how are you making your money?
Right.
And there are so many different aspects of influence, be it from channel, sales, marketing, supply chain, etc. And how your business model work will absolutely just draw the investors to pay attention to things. For example, end user license agreements, or what is called EULAs, if you're just going to roll like a cool kid.
Right.
And so EULAs are just absolutely important for subscription-based business models.
Yeah.
So the investor base realize these are often like semi-retired people who already did what you did, made the oodles of money, and now are trying to invest into the next wave. They're very keen on the contracts and agreement that are basically going to be the engine of your business.
Yeah. And these agreements also are part and parcel of what make up your cost of goods sold or right, your cost of customer acquisition, because you have to pay people to get the products that you're going to sell. You have to pay people to go sell the products that you're going to sell. And you have to pay businesses to give you the underlying pieces that you put together into the widget that you're going to sell. So all of these things are important from a pure business perspective, and they're just as important from a potential investor perspective, because ultimately the investor is just looking and saying, is this a good business? Does it have a cool product, one that has a market advantage? Has the business done what it needs to do to maintain that market advantage by protecting its IP, by entering into strong contracts that give it strong, long-lasting rights?
Well, and then let's just go back to the business model perspective. If you have an agreement with certain locked prices for a specific amount of time, guess what? That influences your pro forma or your future financial planning. So not only do your investors need to have access to this, but when you have key financial advisors who are working on your spreadsheets to figure out your projections and where it goes, they're going to also want access to at least
Absolutely.
this aspect of your deal room for things that are pertinent that affect your profit and loss.
Absolutely.
All right, let's go into miscellaneous agreements because this is a wild card.
So miscellaneous agreements is just that, miscellaneous. The first thing you all should know is that what is involved in miscellaneous agreements depends in large measure on the business, the market or industry that you're in,
Okay.
and the investors or potential investors who are talking to you. So if you're in the gas production business, for example, there's going to be an entirely different set of things that a potential investor is going to want to see than if you're in the business of selling ice cream at a really big level. So that's what this is, just a miscellaneous bucket, because that's literally what it is. It's entirely dependent on your business and your potential investors. Having said that, there's a few things that are always going to be, I put them in the miscellaneous bucket anyway, but that are always going to be important for a potential investor, and that is the disputes, litigation, and infringement claims. So they're all kind of the same thing, but spelled out in different ways, and they could be over something other than IP. If your business is in a dispute, again, this is a red flag for a potential investor. You're going to need to explain that dispute. And how we have disputes in litigation is, again, my view is that you should be, by the time you're this far into your discussions, you should be being as upfront as possible about the state of your business. And that means if you're in fights with someone about a product, maybe it's product liability, maybe it's IP ownership, maybe it's something, an employment agreement dispute. A potential investor is going to want to know it. Potential investor is going to want to know it sooner rather than later. The later it comes up, the more likely it is to be a red flag, the more likely it is you're going to hit that last stoplight before you catch the cash plane. Having said that, the other area is, of course, IP. In many instances, the IP drives the value of the business along with sales and things like that. But the core, the nugget in a particular business is intellectual property. If someone else claims to own that intellectual property, even if you believe that it's not a valid claim, it's important to identify, and although we have it say agreements here, it's not necessarily agreements. It's important for you to identify for the potential investor that those allegations are there, and of course, to provide your reasoning, your logic, your analysis of why those allegations don't have any merit. And many investors are used to investing in companies where there is some level of ambiguity on ownership and things of that nature. And if you can establish for those investors that your position is the better position, they will go forward anyway. But what will for sure kill a deal is not telling them and having them learn about it some other way. Because not only is that going to be a deal killer just because many don't like it, but it's going to be a deal killer because you haven't told the truth. And
yeah,
lies kill.
it sure does.
Or withholding information kills.
No, honestly. And preparation is really important. I love these best practices, and I can't emphasize enough, by bringing in assistance or a viewpoint from outside experts really can help you look at things differently and avoid just really awkward situations and creating more friction. But Mark, why don't you walk through your 4 points, because I think these are great.
Well, so I would say this, everything is easier to do right the first time. Everything is harder to do right later. So
or more expensive.
Start and yeah, or both.
Yeah.
And usually the one leads to the second. So if you start from the beginning and you start from the position of I'm going to eventually seek funding. I know that I'm going to seek funding. I know that I want to operate my business in the proper way. I know that I need to do things properly, i.e., starting from the start is the best way to both run your business and to have a due diligence room that's easy and less stressful for you, smoother for the review, smoother for you to get from request to funding. So starting from the start is number one. Prevention and guidance are much cheaper than fixing the problem afterwards. We talked about this, but basically, you don't want to be penny wise and pound foolish. If you've hired or talked to the right kinds of advisors, they understand that if you're a seed level company or a pre-seed company, you don't have tens of thousands of dollars to have your lawyer or your accountant create the Rolls Royce of formation documents. They're going to understand where you are and what your resources are. They're going to talk to you about that. And then they're going to help you put the needed work in for you to have the best possible documentation, in my example, formation documents, for where you are in your business and where you are financially. It doesn't mean that it's not going to cost money sometimes, but it is almost always better to do things right. It is always better to do things right first, and with the right kind of guidance, the right kind of advisors, you can put your money where it matters most.
Well, and let's dive into this, because in Boom Startup, everybody knows we have our quarterly business surveys. We like checkpoints. We like to hear updates because we're just tracking to see, is the growth rate on par with what we consider high potential, high growth companies, right?
Right.
Now, Mark, let's talk about early stage startups. They're making a lot of decisions quickly. And how important is it to have someone come in, like maybe an hour a month, etc., just to understand what's going on and provide that sort of outside perspective as an expert, like as an attorney expert, etc.?
Yeah, I think that people believe they can get by, and sometimes you can get by for a little while, not involving an expert or particular advisor with subject matter expertise along the way. But again, it's a prevention and guidance, penny wise, pound foolish situation in most circumstances. There are fractional CFOs, there are fractional outside counsel. I mean, outside counsel basically is call, and it's an hourly rate to get discussion about problems, etc. And it goes back to our earlier conversation, which is, if you're a business owner, you have so many things, a founder or a CFO or a CEO, so many things that are on your plate, so many things that are business focused, that it makes little to no sense to also try to be a lawyer, an accountant, etc. And so finding the right advisor, finding an advisor who can give you that advice at a reasonable rate, at reasonable intervals, with a solid understanding of your business and your risk tolerance, and I think that latter bit's important, will help you to make the right moves for you, for your business at the right times, and help you to decide when to spend the money, so to speak, and when you can get by without spending as much money.
Well,
so that's what I would say.
I live by the phrase to always surround myself with people that are better and smarter than I. That's why you're here.
Yeah.
That's why you're here. But I think it's really healthy because the CEO, even though they're the most responsible and the figurehead for the organization, if they have the right sort of high-level advisors to make sure that they're seeing blind spots and they're understanding the sorts of risks, still the decision is up to the CEO as to how to pursue. I mean, this goes well beyond funding preparation. This really goes into being the leader and having that trusted group to help be your soundboard and to make sure that how you're moving the business is in the proper direction.
Yeah, I totally agree. I mean, I think that's prevention and guidance, and getting the guidance early and, relatively speaking, often. Not for everything all the time, but relatively often, and at regular intervals. I think the regular interval checkups make sense because, as I say, you got a lot going on, and sometimes the question may come up while you're in the middle of something else, and too much time goes by, and so either the CEO or founder just took a flyer and decided they would do whatever they were going to do rather than get advice from their CFO or fractional CFO, or they don't make a choice, but by the time they do talk to their advisor, they've forgotten that the issue came up. And so a regular check-in, regular contact with advisors just makes more sense, because you're going to deal with the issue more quickly and more closely to when the issue came up. And you're probably also likely to get better direct advice in that scenario, which ultimately, again, leads to allowing you to focus on the business side of things.
Well, and we did get a question come in more specifically about legal business. How should founders evaluate or begin that sort of legal advisory relationship? Like, what questions should they ask? Is there an assessment, etc.? Well, how do you handle, and support and engage founders?
Yeah, so that's a good question. So I think that there are two primary things that I would say are important. The first thing is, do you mesh with your potential legal advisor? Do you get along well? Do you understand each other? Do you communicate well with each other? And that's going to be something that's largely, a gut feeling, because you're going to have to decide relatively soon. You can always change your mind, but you're going to have to decide relatively early on in your relationship, and it's going to be hopefully over coffee or drinks or lunch or something, where you're just figuring out if you mesh well. The second thing I would say, and this comes from me, and it's a personal thing, a personal preference of mine, is you want breadth of experience. And in my view, I'm a litigator, so I can say this: litigators have the best breadth of experience and view from the right kind of litigator. Because if you're a family law litigator, maybe not, but if you're a corporate business litigator, you have seen it before, whatever it is: employment disputes, intellectual property disputes, contract disputes, disputes between founders, dispute between shareholders, all derivative lawsuits, all of those sorts of things come up in every business. They don't always make it to court, and hopefully you can do things correctly to avoid most of those things making it to court. But you want someone who has seen it, because if they've seen it, they can say to you, that's important, that's a little less important. And they can do that because they have seen it all before. And hopefully they can apply not only their broad base of knowledge, but their understanding of you and your risk tolerance to give you the kind of advice that says, you know what, this contract has a litigation provision that says you have to sue in Sri Lanka. Well, that could be really expensive, and it could be worth fighting about, or it could be for the paper that you put in your bathroom, and no one cares, so it doesn't matter. But if it does matter, you probably want someone who can look at it and say, guess what? We shouldn't have that kind of provision. It's worth negotiating. It's worth fighting for. It's worth spending your money on. The one isn't, the other is, and you want someone who knows the difference. And that's obviously an extreme example, but generally speaking, litigators can tell you when it's worth fighting about, when it could become a source of a problem, and when it couldn't. And I said only two, but I should add the last one. And generally speaking, you're going to want someone who's done, if you're looking for help with due diligence, you probably want someone who's worked with other companies like yours about the same size and about the same market. to help them get ready for funding. So if you're not looking for that in particular, then I would go back to my first 2 points.
Yeah. No, I thank you so much, because we're often asked, like, how do we find the right mentor? How do we find the right advisor? And, how can we get the most out of the relationship? So these tips from your perspective is so helpful.
Yeah.
I'd like to thank you so much, Mark, for joining us today. And I'd also like to encourage people to participate in our upcoming events. We have a Traction and Growth Pitch Up Help, which means that we're doing a deep dive on the investor pitch slide that covers traction and growth. This is particularly important to nail, especially if you're pre-revenue. It's still possible to show that your business opportunity and your business itself is growing and that you have traction within the right market. Additionally, we're doing entrepreneur mixers, and we have an OpenUp employee stock option fundamental on the 30th of November. That too will be a live event, and it's going through how to run an employee stock option plan and the different filings such as 409A that you need to have along with it. Stock
That's
options
exactly a spot where we were just talking about advisors. I know what they are. I can probably write up a good bunch of legal documents to set it up, but talking to someone who is a expert in that area, so you form it correctly and operate it correctly, are vital.
Well, and distributing those shares,
Yeah.
right? It's
Part of operating it.
Operating is a pretty big deal. So I hope you can join us again for these funding events. And again, for the new viewers of Boomstar, welcome. Thank you so much for joining us. Our promise is to really work with you to encourage your success, and definitely participate in our quarterly business reviews. Definitely leverage our mentor experts such as Mark. We're here to help. Thank you so much.
Yeah, thank you.